Hey, everybody. Welcome to Thursday night. Back at it again on this Thursday night, like we are each and every Thursday, except for last week. My twin daughters were graduating from high school, and so had to be there for that. But we're back here on the Consumer Warrior YouTube channel. My name is John Skiba. I'm a consumer protection attorney and a bankruptcy attorney in the state of Arizona. And each and every week, we do this where we discuss topics related to defending debt collection lawsuits, filing for bankruptcy, and just dealing with serious debt problems. So the way that we do it is you can go ahead and in the chat on YouTube, go ahead and put any questions that you may have. I'll put them up here on the screen and we'll talk about it. As always, I have to give my lawyer disclaimer that I'm only licensed to practice law in the state of Arizona. I'm not licensed anywhere else. You shouldn't construe anything that I say as legal advice. This is us chatting on YouTube. And if you need an attorney, I highly recommend you contact one in your state who knows the laws. If you are in the state of Arizona, you can get my contact information below. We do free consultations with bankruptcy. We do them with debt collection lawsuits. And I'd be happy to talk to you and see how we can help you out. Again, that's only for Arizona people. Unfortunately, I get a lot of people who call me from out of states, and I can't help you just because I'm not licensed there. So let's jump into, I saw there's quite a bit of activity already in the chat. But I did want to start off with a couple of questions I pulled from the comments as I was going through there that I thought would be applicable to everybody. The first one said, this was the person said, I said, the only way to stop a garnishment on a default case is to declare bankruptcy. But I filed a form to reopen the case and now have another hearing to handle this matter. Is this normal? I think probably what I said, so if you have a default judgment and they actually are garnishing you, you've lost a ton of leverage. I mean, they're getting money. Unless you quit your job or get fired or something, they're just going to continue to be able to rake in money and take that 25% or how much ever it is they're taking from you. So you don't have much leverage. And so bankruptcy is where those things often lead. I can tell you the number one thing that precedes bankruptcy for most people is like wage garnishment. If that gets hit, they usually file because you don't have a lot of leverage to be able to get that done. So, that's awesome that you filed a motion to reopen it. I guess the only thing I would want to know is the motion to reopen it. They set a hearing on that. They may just be wanting to do oral argument to see if they should set aside the default judgment. Or sometimes if there's a garnishment, you can object to it. The court will hold a hearing to see if there's any legal basis to stop the garnishment. And if not, then they're going to allow it to continue. So you may want to see exactly what it is that they're doing there. But the fact that you got a hearing means that it might be a good time to reach out and try to settle the debt at that point. Maybe offer some type of lowball offer and see if you can get them to bite on that. The other one I saw that I thought would be good to go over. It said, hello, would it be possible to pay my car loan off with a credit card and then file bankruptcy? All right, now we're getting a little too tricky here for our own good. So when it comes to bankruptcy, the idea that can cause problems on multiple levels. So my short answer is don't do that. But here's the kind of problems it could cause. If you pay off your car loan with a credit card and then file bankruptcy, trying to get rid of the credit card debt, that can be an issue because if you buy debt or get cash advances on a credit card within 70 to 90 days prior to filing, the credit card company can come in and object. But not only that, bankruptcy, I always say it's kind of backwards world. It's almost better to have loans against your car in bankruptcy than not. And the reason why is if you own your car free and clear, if it's totally paid off, then the court or the bankruptcy trustee can look at that and see how much of it is protected under the exemption in your state. So for example, in Arizona, where I practice law, the car of up to $6,000 in equity is protected. Well, if the car's completely paid off, that means that we don't have to subtract, the lien or the note against it. So let's say that your car is worth $15,000 and it's paid off. Well, your exemption in Arizona is only $6,000. So the bankruptcy trustee, what they would do in that situation, they would take the car, write you a check for $6,000 to cover your exemption, and then the rest, the other $9,000, would go to your creditors. Whereas let's say you had a same situation, but you had a $9,000 loan against it, then that's not a big deal because your car is worth $15,000, you owe $9,000 on it, so there's like $6,000 of equity. we can apply that exemption and you can protect the vehicle. So long way of saying don't do that. You're going to get yourself in trouble, and it's probably going to hurt you actually worse in the end. So I wouldn't do that. So Al, thank you from Tucson, and just sent you an email. So check your email. I just corresponded to you from earlier today. Appreciate you supporting the channel each and every week. All right, let's jump in here with Benny. Says Bank of America law firm is not budging on settlement. Won't do less than 75%. They're working directly with Bank of America. Hearings next month. Any options to still dispute to a lower amount? I always break debt collection lawsuits into two groups: junk debt buyer and original creditor. Junk debt buyer lawsuits, they will settle for much less. I've had them settle for as low as 10 cents on the dollar up to, right around 25, 30 cents on the dollar. Original creditors, and Bank of America is the one where often they'll bring their own lawsuits. They know that they have, kind of cornered. Unless you have some kind of identity theft issue or something like that, they're going to have the documents they need. They're going to have witnesses. They're going to be able to come in to testify to the things that they need to testify to. So you'll see them. You see American Express do this, where they generally are going to want somewhere usually between 60 and 75%. They may come down a little bit, or they may be willing to break it up into payments or something like that. But unfortunately, those ones are kind of tough. Unless you can show some type of serious hardship, like you're going to have to document it for them. And then you get into the whole thing of whether you're showing, your financial information, stuff like that you got to be careful of. So unfortunately, that one, you're probably not going to get too much of a better deal on, unless there's some kind of, other circumstance that's going to influence it. All right. Tiffany says, good afternoon. I had a Synchrony furniture dispute through Synchrony for furniture not delivered because of the pandemic. They credited the amount, but left fees and did a charge off to Midland Credit. Now what? Okay, so they gave you a credit, but they left fees, and then they charged it off and sold it to Midland. What you're going to have to do, because if Midland's saying that there's a debt that's owed, you could raise some of these defenses. I guess you'd have to show, I don't know if truthfully it's going to be that much different than your typical credit card debt, because what's going to happen is, they're still going to have to come in and prove that the underlying debt was there, which, they may struggle a little bit more there, particularly if there was a problem. If they refunded the money and they gave you a credit because of the furniture was not delivered, I think that would be an absolute defense, because the only reason why there would be fees there is if you didn't pay it legitimately, if there was some kind of issue there. So I think that would be a good defense that you could raise, where you're actually just, bringing up the underlying credit issue and saying, look, we never even got this. And now they're suing us for the fees. And even if they sold it off to a debt buyer for the fees, I think that's a winnable case. I think that's something that I would continue to push. So, all right, let's talk to Taylor. Taylor and DA here in the chat section. We're having quite a conversation pre-show before we went live. We'll go through this quick. So Taylor says, I was sent a letter from a company on behalf of Allstate asking for 50,000 American dollars from a car accident where I was underinsured back in 2018. I called to ask for proof that I owe that. What should I do? They'll probably provide you with proof, but I know you went on to say that you're thinking of filing a Chapter 7, although I do have quite a bit of money saved in crypto. Now, you bring up a good point, and this is one reason I wanted to bring this up. I noticed this on the bankruptcy schedules. They're amending these documents frequently. One thing they require you to disclose now is any cryptocurrency. And I was at a meeting of the creditors, and one of the trustees asked about that. They said, hey, do you have a Coinbase account? Do you have any kind of crypto account where you're holding some type of cryptocurrency, like Bitcoin or whatever? So this is something that the courts and the trustees are aware about, and they're going after. And so if you have a bunch of cryptocurrency, you're going to have to disclose it. Not disclosing it is a felony, and you'll lose it. They'll come in and they'll try to get that transferred and liquidate it. So that's something to be aware of. And then you also go on to say that whether Chapter 7 or 11 would be best. I don't have a job at the moment, but I do have a bit of savings. Two things there. Chapter 11 is typically for corporations or people who have huge amounts of debts. We're talking millions of dollars of debt, and they don't qualify for a 13, or their income's too high for a 7. For the overwhelming majority of consumers that file bankruptcy, it's a Chapter 7. Those who have income that are above the means or above the average for your state, they're going to file a Chapter 13, or if they have like a house in foreclosure or something like that. So usually it's going to be Chapter 7. Obviously, I can't tell that without knowing your whole situation, but just 11 is typically not something we see a whole lot of. There's actually very few 11s that are filed relative to the other chapters. So, and the fact that you have a bit of savings. So if you're in the state of Arizona, you can't have a lot of cash on hand when you file for bankruptcy. And in fact, on the day you file, you can have only $300 for an individual or $600 for a couple. Now, it only applies to that one day of filing when you actually file the documents with the court, but it's kind of tough because you can't have a savings or reserve, which is a little backwards, I think, because if you're going into the bankruptcy process, you would think that you would need some, extra reserves to kind of restart over and, build out of it. So, because of that, for sure you need to talk to an attorney, and before you jump into a bankruptcy, if there's a bunch of savings, because you could end up losing it. I know you go on to say here that, let's see here, that you might trade some of your money, no job, no house, car, savings. One thing you need to be careful is if they get a judgment against you, they could try to garnish those bank accounts. And it just happens. You don't see it, and then it causes you all kinds of problems. So, all right, let's see what Benny has to say. It was in a hearing when a judge didn't want to accept the arbitration clause. The plaintiff argued it didn't count in small claims court. This was debt buying portfolio. Now, it is true, most of the arbitration clauses that I've read say they do not apply to small claims court. The thing you need to look at is if you're truly in small claims. So like Arizona has a justice court system that deals with disputes where the amount in dispute or in controversy is less than $10,000. And as a subset of that, Arizona justice courts have a small claims court that deals with claims that are under $3,500. But the kicker there is that there are no attorneys allowed for the plaintiff or the defendant. So a junk debt buyer that's arguing this, they're going to have an attorney. So I would double check, because I've had attorneys try to pull that before. And I'm like, look, we're not in small claims court. We're in justice court, something totally different. And so I would just confirm that that's exactly where you're at. All right. Chuck says, Portfolio Recovery Associate sued me and I filed my answer. I admitted that I had an Amazon card through Synchrony Bank. I filed my answer, raised an affirmative defense that PRA is not the correct owner of the debt. I also filed a motion to compel arbitration. I feel like there's more to this story, but you're doing good, Chuck. You're right there where you need to be. You file the answer, so you don't get the default. The affirmative defense, the PRA is not the correct owner. And again, affirmative defense is like the civil version of self-defense. In a criminal case, if you kill somebody, it's the equivalent of saying, yeah, I did that, but I had a legal excuse or a legal defense. It was self-defense, or it was insanity or whatever it was. You're saying, even if what they're saying is true, I do have a defense to that. So the affirmative defense was correct because you're saying, hey, they're not the correct owner. And then you filed the motion to compel arbitration. I knew it. I knew there's more to this. It's due to be ruled on this month on the 8th. What happens next? This is a perfect segue because I have a new video coming out. It'll either come out tomorrow or on Monday. Those of you that follow the channel pretty closely, if you haven't subscribed yet, please click subscribe. You may notice that I'm putting out a lot more videos. That we're doing 3 a week now. We've done it now for 2 weeks. I have actually engaged in a true video editor. So someone who does it professionally, doesn't just hack things together like I've been doing. And so I know that one's coming out because I've already recorded it and they're in the editing process. It's either going to come out tomorrow. They're released at 6:00 p.m. Pacific Standard Time on Monday, Wednesday, Friday. So I do a whole video on what happens after you file a motion to compel arbitration. But here, in a nutshell, here's what happens. If the court says, okay, the court can do one of two things. They can say, okay, we're going to compel arbitration. Case is dismissed. Go deal with it over there. Or they can stop the court case and say, look, you have 90 days to go get this thing dealt with in arbitration. And if you don't, come back. Here's the issue. Here's the issue you run into that is, so when it comes to arbitration and the arbitration clause, it basically says the parties can elect to have their disputes resolved through arbitration. And it talks about the party who has the claim bringing it. Now, usually with debt collection suits, it's not you that has a claim against the junk debt buyer or the original creditor. It's, Midland Funding, Portfolio Recovery. They're asserting a claim against you. And so it always seems weird, when they say, hey, they want the defendant to file the actual claim in arbitration, in private arbitration, because you're not alleging any claims against the junk debt buyer or the creditor. So what I usually recommend doing is, if the judge does that, then you should send something in writing, whether it's email, a letter saying, okay, the judge has compelled arbitration. You say you have claims against me. Here's where you should file it, JAMS or AAA, and see if they do it. And they won't. If they don't, then when you go back to court, you can say, judge, look, here's what the arbitration clause says. It says if they have claims against me, this is where we're going to have it resolved, is in private arbitration. I sent them a letter and said, okay, go ahead, let's do this. If they don't do it, that's a reason to ask for the case to be dismissed for failure to prosecute it. So that's what happens. But again, that video, I have a new video coming out, and I think it's going to be tomorrow, but check for that. Subscribe, and then you'll be notified when I do release it. So, but check that out, because I go into a little more detail than I did right there. Alex, thank you. You're going to ask about the video editing. Yeah, we're getting all grown up now. Getting somebody who really knows what they're doing with this, which is good. And I appreciate everybody who reaches out to my practice. We get a lot of work from YouTube, and I appreciate that as well. And so it's something where I want to put more efforts, not only to provide information and content that'll help you guys out, but actually helps out my law practice as well. All right, let's see what DCR has to say. I answered a suit brought by LVNV for $1,200-ish. They are represented by a law firm. How is it worth it to LVNV? It seems like such a little amount to recover versus paying a lawyer to get it. That's a good question. And, it's actually different. It's kind of backwards from what you would think. I've talked to I deal with the same attorneys over, and they say, look, they usually will actually bring the smaller dollar suits sooner or more quickly or more often than they would like a big dollar one. So it's very rare when I see a junk debt buyer bring like a $50,000 credit card lawsuit. And the reason is, when people get sued for $50,000, they file bankruptcy. You get sued for a $75,000 credit card, you're going to file bankruptcy. Very few people are going to file bankruptcy over $1,200. They know they're either going to get a judgment or they're going to get a settlement. And so I literally, just a couple of weeks ago, I saw one that was like $480. I mean, the filing fee to the case was like $110. And then the process server was like another $150. So the reason why they do it is because, one, they try to tack all those costs on. And two, it's how their attorneys are paid. Often debt collection attorneys are paid on a contingency, where they get 25 or 35% of anything they collect. So a company like LVNV maybe not be out anything, where, in getting the attorneys to deal with it, they may go ahead and file it. And then, if they collect, they get some money. And if not, then LVNV doesn't care. So that's why. That's how it all comes together. So, all righty, let's see here. I don't know if I know the answer to this, but we'll look at it. Recently, the Biden administration has or is going to discharge federal student loan debt for Corinthian College, Inc. How does this apply for private student loans used for CCI? I don't know. But I saw that. I saw it on the news last night. Corinthian College is one of these private schools that went belly up a long time ago and left a lot of people with a lot of debt. And the forgiveness is in the billions of dollars. There was a system in place. There is for private schools that go out of business, where you can apply to have student loans debts discharged. My understanding, and I don't do a lot of student loan type negotiations. If you're having student loan problems, I would recommend you go to the studentloanlawyer.com. Eric Cohen is, I believe that's his name. He's one of he is the preeminent one out there. Does a great job. And so I don't deal with that, but I did see that. I've heard that what this does, the Biden administration in doing that, it just makes it, you don't have to go through the application process. It's really just more of an administrative thing where I'm going to assume you're going to get some kind of letter saying, hey, you don't owe it anymore. So, yeah, Alex, I've seen, and the reason why it's worth it is because the judgments accrue interest, and they usually accrue interest at the contract rate of interest, which was usually like 29, 30% at the time the judgment was entered because there's a default. So it's not unusual to see that $400 judgment if it just sits out there that, 8 years down the road, now all of a sudden it's like $3,000, $4,000, whatever it is. So, all right, let's see here. It says, hi, I'm from Texas. I just got served by the original creditor, but in the plaintiff's claim, they're suing for damages, which is my debt, but also attorney's fees. Can I answer back that I deny this? So, when you're responding in an answer, I usually say there's really 3 responses that are acceptable. You can admit what they're alleging, you can deny it, or you can say that you lack sufficient information to either admit or deny, and therefore you deny. I'll say it again. You lack sufficient information to either admit or deny what they're alleging, so you deny it at this point. Basically, you're saying, I don't know. I don't have enough information to be able to know what you're talking about here, so I'm just going to deny it for now. Now, attorney's fees, I can tell you, like in the state of Arizona, there's a statute, Arizona Revised Statute, ARS 12341 and ARS 12341.01. It allows for the recovery to the prevailing party in a civil lawsuit, their attorney's fees and costs. So I don't know if there is something like that in Texas, but it could be. So, if you don't know if there is, you could just say that you don't have enough information, so you deny it at this point. The thing when you're filing an answer, you need to make sure that you're 2 things. One is that you're truthful, but 2, that you're accurate. And sometimes being accurate, it's a little more difficult than you think because, they'll put, often in a lawsuit, they'll put, okay, this person owes $6,259.22. Unless you know for sure how it is they came up with that number, I think it's appropriate to say that you lack sufficient information as far as whether it's true or not. And so you deny it at this point. I always say you don't have to make up for their poor drafting. If they're not going to put something in there that's clear and that is verifiable, then I think it's fine to deny it. You got to be truthful, though, in what you submit to the court. All right, let's see here. Natus is back. Navy Federal hired a debt company to collect $25,000 from me, and I already told Navy Federal I can't pay 33%, and the new debt company is asking for 50%. What percentage is a good settling point? So it sounds like Navy Federal has hired a debt collection company, maybe not sold the debt, but they have a debt collection company. Again, you're dealing with the original creditor. Clearly the number is somewhere between 33% and 50%. But you're saying you can't pay 33%. The larger the debt, often the lower that they'll take. So if they owe 25, I would start the settlement offer around 8, maybe pay offer $8,000 or $6,500, something there. It's going to be in that range, somewhere between probably like $6,000 and probably 10 is what I would anticipate to get it done. And that's if it's in a lump sum. If you're wanting to do payments on something like that, they're going to want a lot more. They're going to want near the full balance, but you need to negotiate to be able to make sure there's no interest, that kind of thing. All righty. Let's see here. This one says, I'm in Arizona in a Chapter 13. I know we start off with the $300 a day of filing, but after that, are we able to save money, any kind of money, or will the trustee take it? So the $300 limit is applicable to the day of filing only. They don't care, if your paycheck comes in down the road or whatever. I can tell you this, with the Chapter 13, it's really not designed to allow you to save money. If you were to, because the idea behind in the bankruptcy code and the whole Chapter 13 process is that you are going to pay your disposable income to your creditors for anywhere from 3 to 5 years. And essentially after you've done that, after you've given it your best shot, then the court will wipe out the balance on credit cards, medical bills, personal loans, that kind of thing. And so there's not really a mechanism for saving. What they do, at least in Arizona, is they allow you to create a budget where they give kind of allotments, like for groceries and for utilities and that are often actually more than what most people spend. And so you can kind of build that into your budget, to kind of have a little bit of emergency fund, if you will, but not a lot. I mean, if you have a ton of cash or there's a ton left over after you pay your monthly plan payment to the court, it's possible that they're going to ask you to bump that up. So, Natus, thank you. I appreciate that. All right. Let's see. Bobby says, can a person be sued in a state they no longer live in? The suit was filed long after they moved out of state. So that's a good question as far as where can you be sued. Now, usually you're sued in the place where you live, where the defendant lives. Some states will allow for the lawsuit, though, to be filed where the transaction occurred. So if they can show that that there was a contract, if it was with a local creditor, and there was was entered into in Mesa, Arizona, where I live, that jurisdiction could be proper there. It's usually though where you live, and so I have a case right now where the client was sued in the wrong state. I'll often raise the issue of, hey, look, the venue's incorrect, and at least try to argue that that could be an issue. So, hey, Angie, thanks for being here tonight. All right. Oh, let's see what Marlene's saying. I skipped her. I've got to scroll back up. I need to get I have an editor now. I think I need to get someone to scroll through the comments. Well, Marlene, I'm not seeing your question. Maybe repost it so I can take a look at it, because I am not seeing it, at least in my list of questions. Let me scroll through one more time. Yeah, I don't see it. So yeah, go ahead and do that. If you want, Marlene, I'd be happy to do that, but I'm not seeing it in there. So somehow I missed over it. So, well, good deal. And that is, thank you. Appreciate it. So, Marlene, the clock is ticking. We can't have dead air. So if you want to quit hurting, kind of cut and paste that or throw that up there, I'd be happy to take a look at it. So, but if not, we can always do it next week too. So, but yeah, so the one thing I would ask is check out some of these new videos. Let me know what you think. Trying to address a lot of issues, kind of deep dive into the bankruptcy process. I worry that the clouds of recession are coming. It just seems like I was an attorney during the last recession in 2008, and it feels very similar, particularly here in Arizona, where the housing prices have been gone sky high. And now it kind of feels like they're starting to come back quite a bit. So anyways, we'll follow up with Taylor. We'll finish this one. If I decide to transfer my money to a crypto exchange to try and trade it, but I end up losing it, will that be a fraudulent transaction? I don't know. You said trade it while trying to make more. Love your content videos. Thank you. I don't. I probably don't know enough about crypto. I have like a little Coinbase account, and I watch it and realize that Bitcoin is so volatile that I don't know if I have the stomach for it. So I don't know if I quite understand, but if you lose money through an investment, that's not a fraudulent transaction. When you're looking into bankruptcy, fraudulent transactions, there's two kinds. I mean, there's one, like fraudulent transfers, or when you transfer something to like a family member or a friend within a year prior to filing bankruptcy, but don't get anything in exchange for it. So like you transfer the title to your boat to your sister or whatever, so you can go through bankruptcy with the idea of bringing it back. That can be an issue. But something like that, where you invest money into something and then you lose it, that's not going to be that's not going to be something that would cause problems, at least is my understanding of it. But that may be a crypto thing that's that may be different than what I'm thinking of there. So Marlene is telling me to wait. Okay, Marlene, you're right. You're definitely on the clock. Type fast. Husband had a Credit One card. I've heard this story before. So unless that's it, Marlene. Anyways, so I'll give it a couple more seconds there. But yeah, so check out some of these new videos we're putting out, and the long-awaited video of this, the kind of the follow-up of what to do after you file the motion to compel private arbitration. Check that one out. That one should be coming out pretty soon. Tell you what, Marlene, go ahead and post it on there, and I will respond back to it once, even once we're done here. You can put it down there in the comments, and I'll respond to it personally. But hey, appreciate everybody checking in tonight. We had a good group tonight, good crowd. Appreciate all that. Again, always put questions, any comments in here. I do go through them, try to respond to them, and we will. Oh wow, okay, Marlene, I literally have my cursor here on the end broadcast button. We'll do this one. Okay. So here we go. Husband had a credit one card, tried to make pay arrangements, had them stop the card so we could catch up. They wouldn't do anything but charge an overage fee. So you tried to make the payment arrangement, have them stop the card so we could catch up, but they're not willing to do anything. Okay, so they're charging you the late fee monthly. So you're trying to work out some kind of negotiation with them, and they're not willing to do it. And that's the one thing, I mean, they're not required to. I mean, the one thing with settlement, you can't force anybody into it. I have a case right now, which is, just the facts of it are really, really horrible for the consumer, but you can't force them. And so now she says, Marlene, you're saying you're being sued by a junk debt buyer. Do we have ideas on this? Well, I mean, the first thing is to make sure you're responding to it. You need to, if you're getting sued, you got to respond. If you don't respond, it's going to be over real quick, and then there's really nothing you do. And so make sure you file an answer to it. And really just a deep dive. I put a link at the top to some of my tutorials on filing an answer and some of the strategies. Watch the other videos that I have here on how to defeat junk debt buyers. The private arbitration clause is one that I've done a lot of videos on, a lot of these live streams where we've talked about it. So the fact that they weren't willing to enter into like some type of settlement program prior to filing suit is not going to be sufficient. That's not a defense. They don't have to settle. A lot of people think too, you get into a courtroom setting and you can offer and tell the judge, hey, I just want to settle this. The courts are not there to put together settlements for you. The courts are there to decide if you're liable or not. And if you're liable, they'll put a judgment in place against you, and then they'll try to let them try to collect on it. But they're not going to go into trying to get that settled for you. So so they close the balances when it's high, and even if you're answering, the only way you can counterclaim a junk debt buyer is if there has to be some type of claim. I mean, usually to me, my counterclaims are maybe Fair Debt Collection Practices Act claim, all that kind of stuff. So I don't usually bring a lot of counterclaims, and there's got to be something legitimate there. So, all right. Adriana wanted to thank me, bought the tutorial for arbitration, payday loan case was dismissed. He ruled for arbitration, and thank you from Memphis. Awesome, Memphis. When I was in college, I spent a week in Memphis because I played in the Liberty Bowl. I played football for BYU, and I believe we played Marshall. Chad Pennington. No, it was Sean King was the quarterback back in the day. I think so that was 1998, but we had a fun time in Memphis. It was awesome there. So, all right, we're going to wrap this up. I appreciate again. Thanks everybody for checking in, and we will